Your Honor, before we enter into a plea,
let's make sure we can get on the record. We're jumping the court reporter here. Are you good getting on the record? Okay, we're back on the record in State versus Clark. We took a 20-minute-ish break so that Dr. Clark could confer with Mr. Hirsch and Mr. Hill. I also ordered up the jurors. I believe they're here. I see some human outlines through the window, but they are outside the courtroom, not inside the courtroom. Mr. Hirsch reported to me that the plan for now is to move forward with a non-negotiated misdemeanor plea. Is that correct?
Yes, I just need to clarify one thing before we do.
Please.
My understanding is, but I want to be on the record, I want Dr. Clark to hear it. The state, I believe, will be asking for some custodial time. We'll be asking for straight probation. My understanding is that obviously the court will make a decision and sentence her, but the court will, let's say the court goes with the state or gives her any time, if the sentence varies from what the defense is asking for, she will be able to withdraw her plea.
Almost right. If the sentence is more severe than what you and Mr. Hill advocate for, then yes. But just as a hypothetical, let's say it's 3 misdemeanors and you're recommending 36 months probation. And I hear enough of this and I say, you know what, it's going to be 24 months probation. That's a variance, but it's a favorable variance. And I don't know why on earth Dr. Clark would say, I don't want that. I wanted 36 months, but I just don't want there to be any surprises. I may vary in any number of directions. If the sentence I impose has more community service than you asked for, if it involves custody and you're not asking for that, then you and your client will have an opportunity to talk about it, come back and say, no, love it, but we'll take it, or no, thank you. And if it's a no, thank you, it's as if it never happened. It's nothing we discuss in front of a jury or anything like that. So it's basically a trial run of what would a misdemeanor non-negotiated plea look like.
Okay, thank you.
All right.
We're ready to move forward. And if you'd like to enter into a contest.
All right, Ms. Smith, are you ready to handle that?
Yes, Judge.
Okay. Do you mind, well, I guess if you don't mind coming up to the witness stand so that Dr. Clark's looking in your direction and she's answering your questions. So Dr. Clark, I'm gonna ask you and whichever attorney, and both attorneys can accompany you up to the podium. If you could be in the middle, that would be great. If you'd be in the middle, and then I'm gonna have, great, Mr. Hill on one side and Mr. Hirsch on the other. And before Ms. Smith starts, I just need to know to whom I should direct legal questions. I may have questions for you, Dr. Clark. I'll just say Dr. Clark and you'll answer. But am I asking Mr. Hirsch or Mr. Hill?
Advisor of her rights. I think I've been on the case longer. If I would say me unless Dr. Clark or Mr. Hill.
Let's do it this way. When Ms. Smith has a question that is lawyer related or I do, we'll start with Mr. Hirsch. You should chime in, Mr. Hill, at any point. I'm not seeking to exclude you in any way, but it's going to be easier for the court reporter if both lawyers aren't answering at the same time. So does that work for you? More importantly, does that work for Dr. Clark?
Yes.
Okay, that's how we'll do it. Thank you. Dr. Clark, in just a moment, Ms. Smith is going to put you under oath, after which she will ask you questions involving your rights as a criminal defendant, certain things about the case. You need to answer her questions truthfully and completely. It is important that you let me or either of your lawyers know if at any point you have a question. If something's going not the way you thought, or someone uses a term that doesn't make sense to you, pause us so that it can be explained in a way that you understand. Will you do that?
Yes.
Great. Ms. Smith?
Yes, Judge. Thank you.
Hold on one second. Mr. Hill.
I'm actually gonna step back. I'm gonna let right now Mr. Hirsch handle this. If I need to, then I'll step in, but I'll let Mr. Hirsch.
Okay. You will stay in the courtroom. You're just not going to be at the podium. All right. So if Dr. Clark wants to confer with you, she don't need to leave the room.
Correct.
You're right there. Okay. Works for me.
All right. Before starting, Judge, this will be a misdemeanor plea with count 1 ag assault being reduced to simple assault. That's OCGA 16520.
And the other 2 counts were already misdemeanors.
Correct.
And it's a plea to all 3 counts.
Yes, Judge.
Understood?
Ms. Clark, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Makiba Clark.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given today?
I take ashwagandha sometimes, but I didn't take it this morning, but that's a supplement. So no.
Okay. And the name of the medication matters less to these proceedings than
No.
what it helps with. What does that deal with?
It's a supplement and it helps with mood and stuff.
Okay. When you don't take that, does that leave you less able to understand what's going on around you?
No.
You don't feel woozy, confused, or out of sorts because you did not take the medicine?
No.
How old are you and how far have you gone in school?
I'm 44 and I reached the level of doctorate.
Are you at this time able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Okay.
In
What are you
other words,
asking?
let's say you wanted a jury trial,
Mhm.
you could obtain one of two ways. You could say, not guilty, I'd like a jury trial.
Okay.
Or if you didn't say anything at all, let's say you just not refused, but opted not to answer any questions, we would have a jury trial. Do you understand?
Silence would mean a not guilty
Okay.
plea. You also could say, I changed my mind, I'm pleading not guilty. That's basically ending our conversation. You go back and sit down and we bring the jurors in.
But with this, I'm not pleading guilty.
You're pleading nolo, but you're not pleading not guilty, if that makes sense. This is where we get legalese.
Middle.
Yes.
Okay. That makes sense. to
And
me.
also, you don't want a jury trial. I think that's the import. You didn't want a jury trial.
Do not
right?
want a jury trial.
Okay.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
Will you give us more time?
You need it.
We do have 48 jurors waiting outside. If there was, let me put it this way, if there was a matter that you didn't cover with Mr. Hirsch or Mr. Hill that relates to the plea, then yes. If you would like to come back in a week, no.
If you're confused about the plea process, oh, wait, what is first offender? Or wait, if I went to trial, if I plead no contest or guilty, why am I giving up my presumption of innocence? If you have any of those questions about the plea colloquy, then
Okay.
please stop and ask. All right. So far, do you need any more time to discuss what has been discussed so far?
I heard you ask a question about the 3 charges and if I was putting in a plea for all 3. Is there a choice to put in a plea for one charge and?
So choice would probably be the wrong way to describe it.
Okay.
The state has made an offer, and that offer, it requires you to plead to all 3 charges.
Okay.
The significant step the state has taken, and only the state can do that, the court cannot,
Okay.
is they've reduced the 1 felony count to a misdemeanor. So your plea, should you go forward, is to 3 misdemeanors. That's legally very significant. No felonies in the mix. Your lawyers probably tried to convince the state to let you plead to fewer than 3 misdemeanors, but the state holds those cards. They could also say, you know what, we're going to dismiss count 3. And so Dr. Clark only needs to plead to counts 1 and 2. But again, that's a district attorney
Okay.
prerogative, reducing charges or dismissing charges. They've reduced 1, so it's 3 misdemeanors. I did not hear Ms. Smith say that she's dismissing any charges. And so this would be a strange outcome, but you could say, I'm only going to plead to count 1. Okay, I could take your plea to that misdemeanor. Then we need to bring the jury in and have a trial on counts 2 and 3. But I've heard you say you don't want a trial on any count. So unless the state dismisses any counts, then you're pleading to every count. It just happens to be now all misdemeanors. And to reiterate, it's a nolo plea, not a guilty plea.
Okay.
Did I explain that in a way that you understand?
Yeah, you did.
Okay.
Let me throw in just the deal the state is offering of reducing count 1, the felony, to a misdemeanor is contingent upon you entering a plea to all 3 misdemeanors.
But the willful obstruction, is that reduced?
That's already a misdemeanor. There is a felony version of obstruction, but you're pleading to misdemeanor obstruction and we're charged with misdemeanor obstruction. Cruelty to children in the third degree is a misdemeanor, but they're not proceeding on that charge. Instead, you'll be charged with a lesser misdemeanor called disorderly conduct.
I didn't hear, is that correct? You didn't
That is
mention that?
correct, yes.
Okay. Thank you for clearing that up. So the state is reducing count one from felony aggravated assault to misdemeanor simple assault.
Okay.
Count two is unchanged. It was always a misdemeanor.
Okay.
Count three, they're changing count three, and you're pleading to a related offense, which is disorderly conduct, so a misdemeanor.
Okay.
So pleading to three counts, not changing the number of counts, but certainly reducing one from felony to misdemeanor.
Okay.
And I didn't know there was that other moving part,
Yeah,
but
totally.
it's okay. Count three is being modified to be a plea to disorderly conduct, which is
OCGA 161139.
great. Thank you.
Yes, Your Honor. And before I proceed, to put on the record, the state is objecting to the defendant taking this plea under NOLO, Alford, either one of those.
Okay.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
I waive the reading of it, but I would like, since I haven't seen it, did you re-accuse it or are you just reducing it on the indictment, on the face of the indictment?
Reducing it on the face of the indictment. We didn't re-accuse it.
All right, but it's just gonna say disorderly conduct. It's not gonna have to be written out.
It won't have to be written out, and this is a copy of the indictment. We're actually going to electronically sign the original. Where it will show up is on the final disposition, a copy of which the doctor will get, and it will show the original charges in the first column. You're familiar with that, but it will be a plea, count one, to the reduced misdemeanor, simple assault, and that's why I needed to get the statutory number. Nothing different with count two. And then count three is going to say cruelty to children, but the plea is to disorderly conduct.
Right.
That's where it will be reflected.
But there won't be a body of disorderly conduct like a formal accusation.
sir.
We waive reading and we waive yes, we waive reading if that was the question.
Ms. Clark, do you remember being arrested on these charges?
On December 20th?
Yes.
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
No.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Recommend a sentence?
They're recommending a sentence other than what we're recommending.
This is the non-negotiated
Okay.
part. Ms. Smith, at some point during our conversation, is going to advocate for a sentence that I've been told involves some time in custody. Mr. Hirsch will be given an opportunity to advocate on your behalf for a different sentence. And as we talked about earlier, if the sentence I finally impose, because I'm not bound by either of the recommendations, I'm informed by them, but not bound by them. If the sentence I impose is more severe in any way from the parameters of what Mr. Hirsch advocated for, you'll have a chance to talk with him and come back to me and say, I'll take it or no, thank you.
Okay.
But if it follows what Mr. Hirsch asked for or is in some respect less severe, you're bound by the plea that we're taking.
Okay.
All right. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
I understand.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
So again, it's a little confusing. You are seeking to plead nolo, and is Dr. Clark seeking first offender status as well?
Yes.
Okay, if I end up agreeing with first offender status and nolo, then it actually, there's nothing permanent about that. You can have it expunged, sealed, et cetera. First of all, it's a misdemeanor, which is harder for people to find who have access to, who have legitimate access, an employer, if you're going back to school to get an even more advanced degree or something. But with the nolo part is a little less fundamental to what I'm saying right now, but with first offender, that's not a conviction at all. You would leave here today with no conviction. You would, if I sentence you to probation, have some probation, but it's not a conviction. And as long as you successfully navigated your sentence, which it sounds like you'll have no trouble doing, then it remains never a conviction. Your records can be sealed and then it can be expunged at the end of the completion of the probation.
Okay.
So it's conditioned on you maintaining good behavior during the time you're on probation. But that's the way first offender works, is that it keeps it from being a conviction up front, and then it's permanently not a conviction and expungable if you get through probation with no significant hiccups.
And you would have to agree to that. You would have to,
I would have to agree to sentence you as a first offender.
Okay.
If I agree to that, I don't get in the way of it afterwards, unless, just making this up, 3 months from now, there's a domestic dispute, you get arrested for something. That new arrest would be a basis for me to say, gosh, Dr. Clark, I misunderstood who you were. And first offender, you were entitled to, but you forfeited it because here we are 6 months later, domestic violence arrest. I misunderstood who you were. I'm going to take away your first offender status. So I have the ability to take it away, but it has to be predicated on a proven violation, not just on a whim. But we'd have a hearing, you'd have lawyers for that hearing with a jury. And we'd talk about whether you did in fact violate your probation. But if you sail through probation, once you've got first offender, it's yours to keep and only to lose if you fundamentally misstep while you're on probation.
okay,
Okay. So you'll know when we're done if I've granted for first offender.
okay.
Ms. Clark, are you a United States citizen?
Yes,
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
yes,
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
no,
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
no.
Has your lawyer explained what the First Offender Act is to you?
To the best of his abilities, yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?